Alrighty, we are on the home stretch, the final countdown, as it were. This is the last of the series, at least for today. If somebody comes up with something interesting, then maybe I'll continue it on tomorrow. But I think tomorrow I would rather go back after Snooker B because, well, spice it up a little. Anyway, well, unless something else, I guess, more interesting pops up. So, Legacy Media, again, thinks that he's going to win the day. And he gives us 3 cases to look at. And again, he's doing the Mark Stevens approach of giving one sentence out of it, stripping all the context away from the sentence, so we don't know what we're talking about. What the hell are we talking about? So the first one is Beaulieu versus State. Certainly the assertion of one's constitutional rights cannot be obstruction of an officer, or every assertion of such rights would lead to obstruction charges. I like it. It sounds good. It is talking about obstruction. So we're looking at obstructing a police officer, apparently. Beaulieu v. State. Oh, big red stop sign. Very, very careful. Be warning. Be warning, you will. There's a fight. The cop stops it. The defendant cursed at him and was just being, was that word obstreperous? I'm probably getting that wrong. So, yeah, he was just talking. He was just running his mouth. For speech to the rise to the level of obstruction, it must be reasonably interpreted to be a threat of violence to the officer, which would amount to obstruction or hindrance. To argue with, curse loudly at, or verbally interrupt a police officer while making the arrest of another does not constitute obstruction of a police officer, etc., etc. Because the evidence only shows a verbal exchange. Where was that at? Oh, man, I got lost. Here we go. All right. Defendant contends the Superior Court erred and denies the motion for a directed verdict of acquittal for the failure of the evidence to show more than a verbal exchange, not accompanied by a verbal or physical threat of violence. We agree a mere verbal exchange with an officer accompanied by no verbal or physical threats of violence does not constitute a violation of 16-10-24, which is not one of the things that we're looking at, but I don't know. Maybe I guess we are now. Violence no longer an element of misdemeanor obstruction. Certainly the assertion of one's constitutional rights cannot be obstruction of an officer, or every assertion of such rights would lead to obstruction charges. Now, I don't know if he was arrested for obstruction because he was filming, or if obstruction charges were applied to Central Valley Auditor because he was filming, or because he was refusing to identify when he was required to identify. You're making a huge leap by saying that he was charged with obstruction of justice because he was filming. He was probably charged with obstruction of justice because he wasn't complying with orders, with lawful orders. But as to that big red stop sign, Stryker has some words to say about it. In Stryker, again, there was just words. But you'll notice we hereby disapprove of the cases of Woodward v. Gray, Beaulieu v. State, and Cooper v. State. Beaulieu v. State you may recognize. To the extent that they imply that misdemeanor obstruction still requires proof of forcible resistance or threat of violence, the Woodward opinion properly relied upon cases decided under prior version of the statute which had no application to the law in effect at the time the case was decided, and other cases stem from Woodward. So, yeah, words can get you now. So be careful. Words can turn into obstruction of justice, and we see it here. And whether the striker's words have the effect of hindering or impeding the officer's decision for the trier of fact, we find the evidence, when considered as a whole, sufficient to allow the trial judge to find beyond a reasonable doubt that Stryker was guilty of obstruction. So, there you go. Then he brings up two cases for the same thing, Wynn v. State and Brown v. State. And a police officer is not discharging his or her lawful duty when she makes an arrest of an individual without probable cause or stops a person without specific articulable suspicion that the person is currently involved in criminal activity. Again, these cases are dealing with obstruction. The police officer has to be engaged in actually stopping someone with probable cause or reasonable suspicion. Where was that? It was down in... I thought I had it highlighted. I must have clicked. Oh, here we go. Right here. All right. Police officer is not discharging his lawful duty when he arrests an individual without probable or reasonable or probable cause. Further, an officer is not within the lawful discharge of his official duties when he approaches and questions an individual without specific articulable facts sufficient to give rise to reasonable suspicion of criminal conduct. Why are they talking about that? An element of each of the crimes of which the defendant was convicted is that the police officer involved must be in the lawful discharge of his official duties. That's why they're talking about it. As we discussed in the trespassing section, which is, I think, section 2, and the loitering and prowling section, which I believe was section 3, the police had probable cause for both. He'd been asked to leave somewhere in there. He confirms it. He'd been asked to leave, so whether or not that asking him to leave would rise to the level of him actually being guilty of trespass, that's up to the trier of fact. That's a good lawyer might get you around that. But probable cause that he was currently trespassing, I think, was there. So the police officers in this case had probable cause. This one basically says identically the same thing. Is it still highlighted? Of course not. I'm click happy. Here we go. You may also notice that in Beaulieu, the guy who's using just words was freed. In Stryker, it was sufficient for a conviction. In Wynn, there was a conviction. The judgment was affirmed. The conviction was affirmed. And in Brown, the conviction was affirmed. One of these, the guy was, they saw him run in. Yeah, this one, they saw him run in. They were chasing someone. They saw him run into the house. And then he later appeared on the front porch of the house. The defendant stood in the doorway of the home and prevented the officer's entry. They were chasing a suspect. They had probable cause to chase him because they were trying to apprehend him. Hot pursuit. The warrant exception for, chasing the suspect into the house applies. And then Wynn v. State. This guy, he was sitting in a car. There was open containers next to him. The police asked him for his name. He gave him a fake name. They asked him to step out of the car so they could frisk him. They found his wallet. They asked him if they could open it up. He said fine. They opened it up, and there was his driver's license with his real name and a picture of him. They went to go run it. He took off running. They're like, stop in the name of the law, and they chased him down and caught him. And then he got obstruction of justice charges. So there you go. So that is going to conclude it for at least today. Thank you for playing Legacy Media. I actually really do appreciate it. You put effort into it, and I really do appreciate that. I mean, unlike sovereign citizens, you at least found cases that you thought would work. So bravo to you. So many times people make assertions without any shred of evidence or citations to back it up. So I'm absolutely not being sarcastic, and I know I'm a troll, so you're going to take it sarcastic anyway, but I really do appreciate it. I appreciate the effort. I feel like this is a intelligent discussion, and obviously you're free to disagree with any of the conclusions I've drawn, but I believe I have laid out a very good case for why my suppositions were correct, even though they were just off the cuff, not having had access to a law library at the time I made them. I appreciate the interaction from you, though, Legacy Media, and keep up the good work, and maybe you'll be a lawyer someday. Thanks for watching. Have a great night.